Hello, everyone. Welcome to this week's edition of this weekly Facebook Live. As usual, we're going to kind of address some of the hot topics that are happening this week in immigration, and then we will go and immediately answer your questions. So let's start off with what's happening in the world of immigration this week. Jennifer, let's talk first about TPS and what's going on with TPS.
Yeah, so tomorrow the Department of Homeland Security will be announcing the extension of TPS for El Salvador, Haiti, Nicaragua, Sudan, Honduras, and Nepal through December 31st of next year of 2022. Right now, everything is set to expire October 4th of this year. So that'll extend that. People don't have to re-register, reapply if they already have it. It'll just be automatically extended. And so that applies to their work authorization and their protected status in the United States.
So one of the things that always comes up when we have these auto extensions is what is an employer supposed to do with somebody who has a document that's now expired, but the government has said that it's not expired, that, there's just this memo out there now that says it's auto extended. So what do you do if you have an employer that's like, I got to terminate you because your work card is gone?
So I've actually written several letters to employers for clients where we explain that their status has been auto extended, their work authorization has been extended. We include a copy of the Federal Register notice showing the extension and highlight that extension, and then also include usually a copy of their current work authorization document and their approval notice for that whole process. And so that's kind of all together, that shows you're authorized. And I don't know if you have other things you do, but.
Yeah, I mean, for the employers out there, when you're completing the I-9, you can just note where the card expires. You can just put an annotation in there, auto extended, and then you can cite the Federal Register or even just put auto extended in the date. That is sufficient. If you ever get audited by immigration or have an ICE audit, that notation will be sufficient to remedy any sort of mitigation of fines. So it should be fine. Great. Anything to add on that, Aaron, about TPS or auto extension? Anything else that often comes up with TPS?
No, on the auto extension with the employers from the employees side, like Jennifer said, that sometimes we do get employers who are hesitant to accept it. And so usually a letter explaining it all from your attorney with the copies of the relevant documents should take care of it. And if they still won't accept it, then you really do need to talk to an attorney, because employers really shouldn't be picking and choosing which documents showing employment eligibility that they'll accept.
Great. All right. And then the other thing, Aaron, is that there was a hearing this week on prosecutorial discretion. So maybe start with kind of, walk us through kind of what's happened with prosecutorial discretion since the Biden administration came into power and where we are now.
Yeah, this is one that is quite a roller coaster, but the basics are that the Biden administration released some priorities, and the priorities for enforcement were to do with national security, some people with certain criminal convictions, and basically recent arrivals to the country. And this is in line with what other administrations have done in the past. It's always understood to be in the authority of the executive to set their priorities on how to enforce the laws. Well, they were sued about this by the state of Texas and some other states, and a judge in Texas issued a nationwide injunction enjoining them from using that priorities memo. And the Department of Justice sought a stay of that injunction, and they got what's called an administrative stay, which was just until the Fifth Circuit could hear a little bit more about it. And yesterday, the Fifth Circuit had a hearing, oral argument on the more permanent stay of the effect of the injunction. And I think that it went, in my opinion, it didn't go great for the lawyers for Texas. And I think that it's likely that they will stay the injunction. And what that means as a practical matter is that the Department of Homeland Security will be able to, if I'm right, they will be able to continue to rely on the priorities memo. Now, all this is ridiculous in some ways, because the Biden administration has announced that they're putting out a new priorities memo by the end of this month. which will supersede the old one. And that one won't be enjoined. I guess they could sue to enjoin that one as well, but so all this could be a moot point very soon. But the point is, I think that they're going to be able to continue to exercise prosecutorial discretion.
And in our office, Aaron, how is that playing out for our clients? What are we doing? Are we still filing requests for PD? And if so, what types of prosecutorial discretion are we seeking? Yeah,
good question. So the types of prosecutorial discretion that we're seeking are all across the board, but some examples are we might ask the Department of Homeland Security not to appeal an order that granted our clients relief from an immigration judge as an act of prosecutorial discretion, or to join with us in a motion to grant relief because the client clearly qualifies, or to administratively close the case because there's maybe some future benefit down the line, or they're just not a priority, or to dismiss the case completely. So there's the types of discretion you could seek are basically only limited by your imagination, and how it's playing out. They're considering the request. They're not saying that they're enjoined from doing it, or that they have a pause on it. They're considering the request and getting back to us with their answers.
Awesome. Anything to add to that, Jennifer, about PD? Are we seeing, I would assume that most of our PD requests are here locally in Denver. Are we seeing positive responses from OCC and ICE and others that need to exercise PD?
Jennifer?
You can speak to that. I've only had one request for PD so far, and I actually didn't make it. The government made it, and we declined it. So it was a, yeah.
Why would we decline a request for prosecutorial discretion?
This particular case was a special immigrant juvenile case, and they already have a hearing set before the immigration judge. And so it didn't make sense in this case to close out the immigration proceedings before the judge and then have them have to wait for an interview before USCIS when we could complete their case sooner and probably quicker.
Great.
And we have had requests to do things like continue the case granted. I think we still have some pending requests for bigger asks. But Jennifer's point is a really good one. Not just because you get an offer doesn't mean that it's in your interest to accept it. And so it's always a strategic decision that you should be making with your attorney.
Yeah, and I know another kind of strategic decision is if you do have your removal case terminated, you might lose work authorization. So that's been a consideration for some people too.
Yeah, so that's a really good point. So sometimes the government will say, we'll agree to administratively close, right? My understanding is they'll agree to do that if there really is relief available in the future, right? If it got recalendared, there would be relief available. And admin closure is to our advantage a lot of times because when a case is admin closed, it's still considered on the docket. There's still an application pending. So it means that we can continue to file for work authorization for our client. Whereas if the case is terminated, it's off the docket altogether. There's no live applications and clients just may be in sort of permanent limbo. So that offer of termination really depends, whether it's a good offer or not, really depends on what the ultimate end game is, right? If the ultimate end game is you don't got anything, there's no relief, then termination is a great thing. But if, like in your case, if there is relief and we think it's a good case, we're probably not going to agree to terminate the case.
Exactly.
Great. All right. Another thing that happened this week, another big item is the Remain in Mexico program. So for those of you that don't know about this, the Remain in Mexico program was a program that basically, the purpose of it was to prevent, floods of asylum seekers at the ports of entry. And so Customs and Border Patrol implemented this program called metering or queue management, where they essentially said, you know what? We're not going to process you immediately for your asylum claim when you come to the border. Rather, we're going to make you remain in Mexico and stay there until we have time to consider your asylum claim. And so this process of making people wait in Mexico, oftentimes detained, led to a lawsuit that was challenged in a case called El Otro Lado v. Mayorkas. And it was in the Southern District of California. And on September 2nd, U.S. District Judge Cynthia Bechant of the Southern District of California basically declared that practice of denying asylum seekers access to the asylum process at the border as unlawful. She basically held that it violates the Administrative Procedures Act and the Fifth Amendment Due Process Clause. So at this point, the governments have been instructed to submit additional briefs regarding what the appropriate remedy is now that the case has been struck down. So really good news, because it means that people who have been seeking asylum from Central America and other countries that are coming through Mexico now can have their cases processed at the border as they arrive without having to wait months and months, possibly years.
And this is really an interesting case, because there's actually like video footage of members of Congress going and trying to accompany people to the ports of entry and being basically subjected to the same metering. And this practice is what was struck down. It's different than the migration protection protocols, which still, well, a district court has ordered the Biden administration to reinstitute that program, and the Supreme Court declined to intervene. And so apparently that's being reinstituted as we speak. So there's, to me, the decisions, the court decisions on this are completely inconsistent, but they're going to start that one program where people have to wait in Mexico, but they're not going to allow metering. So.
Yep. All right. Well, that's all I have. Anything else to add? Updates before we go to the questions? I know that people want updates on all the cases that we're litigating, and so let's go straight to the questions. Let's start, Aaron, with any updates on the Go case. What's going on with Go? Where are we with Go? Is
Sure.
Go stopped? Is Go?
Yeah. So let's talk through some developments in other cases, because there's not really any updates directly on Go, but I think there's some other updates in other cases that are giving people anxiety. So in a case called Rosales that used to be called Jacob, that was transferred from California to DC and is also in front of Judge Mehta, the judge denied a motion for class certification and denied a motion for preliminary injunction. But he did it for technical reasons and without prejudice. And so the attorneys who represent those clients already refiled the motions. The problem with that, from my perspective, is that there's hardly a time for them to get these adjudicated, because the government gets a response time to the new motions, and we're already getting so close to September 30th. So whether Judge Mehta is going to make a decision on those motions before September 30th, I don't know. But again, that's about the Rosales case, not about Go. And then there was a case called Gochi, GJOCI. And that was another DV 2021 case. And that case was dismissed for lack of standing. And it was because the plaintiffs who they said had standing were from Nepal, where there had been lockdowns and the consulate had shuttered for a large part of the fiscal year. And what the judge basically said was, even if these policies that you say are illegal were not in existence, I can have no confidence that their cases would have been adjudicated because there were other factors that shut down the consulate. And what I want people to know is that in Go, it's a very different situation. So the cases that we highlighted for standing were plaintiffs from countries where the consulates were functioning and issuing many, many other types of visas, but effectively zero diversity visa lottery visas. And so we have cases highlighted that show that our plaintiffs would have had their cases adjudicated if not for the illegal policies that the Department of State put into place. So I don't feel scared at all by either of those rulings. That doesn't make me feel more pessimistic about the case at all. But the next question is obviously, we're getting into mid-September here. Where's the ruling? What's going on? When's it happening? And frankly, we don't know. I had hoped we would have a ruling by now. But I guess there are a few theories. One theory is we know Judge Mehta was working on DV 2021 cases last week, at least somewhat, because that's when some of the action in those other cases happened. So maybe he's working on them all now, and maybe we'll get a decision in the coming days. Another theory is maybe he's going to wait till late September and see how many cases have actually been adjudicated, and then have an idea of exactly how many visas he wants to reserve, if he wants to reserve them, and then issue a decision then. So we don't know. We have no way of knowing, but we're still hopeful for a good outcome for our plaintiffs.
And this is a good question, Aaron. I mean, given the fact that we're 21 days away from September 30th, there's a couple things the judge could do, right? He could order the government to speed up adjudication, or the judge could say, I'm going to wait and just reserve visas. At this point, which do you think is the more likely remedy?
I think reservation is the more important remedy at this point, because they will, there's just not that much time. So even if he makes an order, they have to gear up, prioritize them, and there's still only so many days. So I don't think it's too late for an order saying that they have to speed visa adjudications. They could order that for a few weeks, and that would be great. But at this point, the more important order is the reservation.
Great. All right, and we have a question. These are good questions on the Chakrabarty case. So the Chakrabarty case, as you know, is the case where we are challenging the waste of adjustment numbers that will literally go away if they're not used by September 30th. And the government has filed a response to our motion for preliminary injunction. They've also filed a motion to dismiss and a motion to change venue. So the question is, what are our arguments against all of this? And I can tell you that, yes, we have a reply to all of this that's due that we will be submitting. Let's start with venue. In the first instance, venue is the choice of the person that files the lawsuit, the plaintiff. The plaintiff gets to establish venue and choose venue in the first instance. In the rules regarding venue are very specific in the Federal Rules of Civil Procedure. You can file the case anywhere where the plaintiff resides, or anywhere where a defendant resides, or anywhere where a substantial part of the events or omissions that gave rise to the injury occurred. In this case, the government lives in every venue. Right? The government actually, CIS lives and works and resides in any venue. So from that perspective, venue is really universal, right? So why do we file in Maryland? The reason we file in Maryland is because USCIS is headquartered in Maryland. In other words, the main office of USCIS exists there. It's important for you to know that not once, not a single incident from the government or the judge has alleged that venue is improper. No one has said that. That's really important. No one has said venue is improper. They're just saying it's inconvenient, right? Because it's inconvenient that we have all this flood of litigation all of a sudden in Maryland. And so the question is it more convenient then to have these cases sprout out all over the country inconsistently in different jurisdictions for judges that have no idea about immigration? Or does it make sense to really consolidate these cases either in Maryland or in DC, which is where we used to file them before the USCIS moved to Maryland? Again, we're going to come out of the gate very, very strong on venue. Not only do we think that venue is appropriate, but that it is inappropriate in this case for the judge to change venue. It would cause more burden on the plaintiffs. It would cause more burden on the government. And frankly, the government is arguing against itself in these cases. Because in DC, they're arguing that the venue should be changed to Maryland. Now in Maryland, they're arguing that the venue should be changed everywhere. So, that's the arguments we're going to be making. We think that venue is appropriate in this case. What we have to decide, to be honest with you, is if we lose on venue, whether we take an interlocutory appeal of that issue to the circuit court, because that really is going to impact not only the plaintiffs in this case, but universally all of our cases going forward. The other thing to know about all of this is that the government has not only requested a change of venue, but they've requested severance of all of our plaintiffs. What that means is they're saying if indeed a plaintiff is proper here in Maryland, and we do have 4 plaintiffs that reside in Maryland, then the others should be severed out of the case, and they should all individually be transferred to their own home states where they reside. So you're talking about, I don't know, how many plaintiffs do we have? I don't even remember. Hundreds of plaintiffs, hundreds of new cases all around the country. So I can imagine the reaction of district court judges around the country when venue happens and all these cases are transferred out. As far as the arguments on the case, I think the main argument that they're making is jurisdictional, right? That the judge has no jurisdiction for various reasons. One of the main reasons for jurisdiction is what we call 242A2B2, which is a provision of the statute that basically says if it is a discretionary decision, you get no judicial review, right? And we know that ultimately a 485, an I-485 green card application is a discretionary decision. There's no argument against that, right? At the end of the day, it's a discretionary decision, but that's not what we're saying. We're not challenging an actual decision. We're challenging the wastage of visa numbers, which is not discretionary, right? I mean, it's not discretionary to be like, yeah, we're just not going to give out visas this year. That is, if that were discretionary, then we would challenge it as a 100% abuse of discretion, which is what we're doing, right? So those are the arguments we're making about discretion. And you know, you'll just have to stay tuned. We're not overly concerned with the arguments that have been made in the brief. A lot of the arguments really just don't apply to what we're contesting. Anything to add, Aaron, based on your review of the briefs?
No, I totally agree. I don't think that their arguments on venue make sense. The venue is completely proper and it's the plaintiff's choice. So I'm not worried about that. As far as the justification for delays and lies, that hearing was just fascinating, bizarre and fascinating. But I think a lot of the things that they said just don't hold up, and I'm really looking forward to challenging them in this reply and further down the line in this litigation. Well, no, I'll just leave it there, and we'll have the reply done shortly, and then we'll be able to elaborate further.
Yeah. Anything to add from you, Jennifer?
That was just an interesting hearing. I will say that.
Yeah, we are, by the way, we are scheduled for a hearing. It is next week. Let me get you the exact date and time. It is next week on, I believe, the Tuesday, the 14th at, is it at 10 o'clock, Aaron? I can't remember.
That sounds right, but I don't have it.
I have it on my calendar for 10 o'clock our time, which is 12 o'clock Eastern. So I will confirm that and we'll send something out on Twitter. I'm not sure if this hearing is going to be open to the public or not. The court has asked us to provide a conference line. So my guess is that this will not be a public hearing, that it will be only for counsel.
And Jeff, is this hearing just for the Chakrabarty case, or are other cases also included?
It's just Chakrabarty, which is good. I think that's really good for us. We really don't want to be messed up with all the other cases because our issues are very, very different. Okay. This is, I'm not really sure which case this person is referring to. It's what is our opinion on whether the judge will accept the class action? I think it's go.
Okay. Osama, like I said, whether they'll accept class action, I don't know. This judge certified a class in DB 2020 in Gomez, but like I said, the motion for class action was just filed, and the government gets its response time, and then there's a reply time for counsel for the Rosales plaintiffs, and so I just don't know whether literally there's enough time for it to happen before September 30th. That's why if I had to guess, I'd say we'll get an order and go before there's any decision on a class action.
Related question. I'm sorry, this one. I'll go to this one here. If the reservation in go, will it be for plaintiffs, the named plaintiffs, or will it be a universal?
So what we requested in our pleadings was adjudication for our plaintiffs. That would mean if the judge ordered what we granted, it would be our plaintiffs would get visas reserved, and they would get priority in that. Whether that's the judge is going to do, we don't know. We just don't know. He ordered in DB 2020, his last order was that they should be adjudicated in a random order, I believe, and so I don't know whether he's going to do the same here. It's a little bit different because that was a class action. This is not. So we just don't know. But we have, Osama, repeatedly alerted the court to consulates that are not working. that are not scheduling any kinds of interviews or that are not doing DV 2021 cases, and noted that they're going to have a workaround for those people. You can't just shut them out of the process. So the way that I imagine that it will work, we're going to make some assumptions here. Let's assume we get a positive order and some visas are reserved. I imagine that similar to in Gomez, the court would order counsel to consult and kind of try to figure out what the plan is going to be for actually issuing these visas. And in those consultations, we will be again alerting them to this fact that they need to create workarounds for plaintiffs in those countries, and additionally, we'll be advocating for our plaintiffs directly.
One other question on Go. What is your opinion on the chances of it being consolidated with the other cases?
I don't know. So he hasn't done that formally so far, and I just don't know.
And he has issued two separate decisions on two separate cases. Or yeah. I guess one decision, and the other decision was from a different judge. But right. So if he wanted to consolidate, he could have done it already with those other cases. So I kind of agree that we'll get a separate order in our case. I think it probably will be the lead case, and that he'll probably cite to that case in the other decisions. All right, let's see. One final question here, and this is for people. This is a Milligan-related question. If you were still in Milligan and your case was not resolved, can you join one of the other individual lawsuits? Like, for example, if you're from Manila, can you join, Ramirez or Penn if you're from Rio?
Yeah, that's the idea. We want to slot people into these existing cases. And so I don't know that we've come up with the exact timeline for that. Do you know, Jeff?
Yep, I don't think we had talked about it. No.
Okay. So, yeah.
It's going to kind of depend. Like, I think all of these are kind of in the motion to dismiss stage. So right. We probably want to get it in fairly soon. Probably want to wait to see if we survive the motion to dismiss. And then if we right. do, then add people. Yeah,
that was kind of my thinking as well, that would make the most sense. So, but yes, the answer is yes. We want to get you into the existing suits.
All right, you all. Well, that is all I have. Any final words or comments or things to look out for this week?
What to look out for this week? What's going on? I don't know.
We have, so just watch out for our response in the Chakrabarty case. Yeah. Also, the response in the King case is now due. We got the government motion yesterday, so we'll be responding to the King case. So I think those are the big ones to watch out for this week. And then the Chakrabarty hearing next week, obviously, which we'll report on as soon as it happens. So thanks again for joining this week, and we'll see you again next week at the same time. Talk to you soon.
Thanks all.
Bye-bye.
Thank you.